New documents in the YNW Melly murder trial have been released. One shows that Melly's ex-girlfriend's mother, Felicia Holmes, still has an ankle monitor on. She was ordered to put this ankle monitor on back in December of 2022. The state also filed a response to the defendant's objection to business record certification and motion in limine. BSO has a records custodian named Kathleen Casey. She's been doing this for 20 years, and Melly's team is trying to get her to not be able to be the records custodian. The state responds basically shatting on this whole thing. So, buckle up. It's kind of funny. Hit subscribe. Here we go. All right. So, first document we got here states motion to strike the defendant's sworn motion to dismiss. So, they're trying to get rid of that whole dismissal shit. Failure to meet requirements. If the alleged undisputed facts are presented and the defendant's motion do not meet the 3-point test, then any response by the state is unnecessary, is what this means. And the motion should be denied. Okay. And that's in state versus something from in 1979. Under the Ellis and Seldmeyer test, the defense motion must state with particularity what facts are undisputed and specifically how they fail to establish a prima facie case. A motion to dismiss that states bare legal conclusions without describing the undisputed facts upon which the conclusion rests fails to satisfy points numbers 2 and 3 of the Ellis and Seldmeyer tests and should be denied from 1977 or something. A motion to dismiss. Another case from 1981. So they're just citing cases where this was, denied. And the case before the court, the defendant's sworn motion to dismiss fails to contain the signature of the defendant. While the defendant's motion notes that he is unable to sign it, that is not true. Wait, hold on. Is there a miscommunication on whether or not Melly can physically sign a document in jail? I'm so lost right now. The motion may be provided to the defendant through jail personnel for him to sign and then returned for filing. Oh, so this is... The issue is him signing it. His offer to sign it in open court later does not make the motion before the court now legally sufficient. Oh, okay. So they're saying either way, it's even if he does sign it, it's not going to change anything. Instead, it attempts to goad the state into a response on an otherwise legally deficient motion. Should the defendant not like the response of the state and the court rule against him, the statements that he swears to in the motion would not be usable against him. Further, the defendant asks the court to strike the information, but fails to address any of the counts against the defendant. Not does it lay out the facts, elements relating to the crime the defendant's proffering would not constitute a crime. For reasons cited in the other cases from the 70s and 80s, the defense motion is legally insufficient and must be struck by the court. Okay. This is an order on the discovery violation situation that happened in jail in my last video. No discovery violation as to the downloads of the alleged victims and the defendant's phones. A signed receipt provided by the state on December 20th to defense counsel acknowledges the state's discovery submission, which full download is available for inspection and review at the state attorney's office. So yeah, they discussed that in my last video, and apparently Raven Liberty signed this, but then acts like she didn't. At least lawyer kind of tripping right there. Another order right here says all evidence for the styled case above shall remain in the courtroom overnight until the completion of the trial or other proceeding. Damn. So they want everything in the courtroom the entire time of the trial. Okay. I don't know if that's normal. I have no idea. That's probably a normal thing. Motion to remove electronic monitor for Felicia Holmes. So Melly's ex-girlfriend's mother apparently still has a electronic monitor on her. That seems very bizarre, right? Apparently her whole life has been ruined. Like I think she lost her job over this too. So Felicia is not happy. December 3rd, 2022, Honorable Court ordered an electronic monitor be placed on Ms. Holmes' ankle to ensure her appearance as a witness at first trial of this cause. And then 6 months later in June, Ms. Holmes testified at trial. We remember that. It was an interesting testimony to say the least. Ms. Holmes then placed the state of Florida on notice that she would invoke her constitutional right against self-incrimination if called as a witness at the retrial of this cause. In response, the prosecutor has listed Ms. Holmes as unavailable. So she told the state she's going to invoke her Fifth Amendment right if she testifies again at this retrial. And now the state clearly doesn't want to do it, and they're like, screw it, we're not going to call her up to the stand. If Miss Holmes is not required to testify at the retrial of this cause, there's no reason to further encumber her freedom with an ankle monitor. Yeah, I mean, that's kind of ridiculous if you think about it. Wouldn't you feel like that's kind of invasive and overboard to have an ankle monitor on for the past fucking year of your life when you're not even going to be at the retrial? All right, so now we have another state's response to Melly's team's objection to business record certification and motion in limine. Defendant filed an objection to business record certification and motion in limine pertaining to the jail calls providing the discovery. The defendant confuses or conflates several issues in this motion. In short, that Securus is a separate company based out of Texas. The stored jail calls are not a business record for the Broward Sheriff's Office, but rather of Securus. The Securus, I guess, is a technology company for fucking jail calls and shit. And thus, an employee of the Broward Sheriff's Office, Kathleen Casey, cannot be a records custodian. This is patently incorrect. There's no requirement that a records custodian by an employee of a particular company. Rather, the requirements are only that the record record is made by a person with knowledge as shown by the testimony of the custodian or qualified witness or as shown by the certification. Thus, the defendant's argument that Casey is not an employee of Securus is without merit. Oh, so Melly's team was saying she isn't an employee, but apparently she is an employee of Securus. The defendants contend that Securus is a separate entity from Broward Sheriff's Office, which is true. However, the Broward Sheriff's Office jail phone call records are kept in their normal course of business. What Securus does is provide the equipment, software, and data storage. Okay. It is Broward Sheriff's Office that maintains the equipment and records and does keep those records in the normal course of business. By way of analogy, Securus functions as Google Drive, providing the data and storage software. The Broward Sheriff's Office is the business utilizing the software and storage for records that are created at the jail. So it seems like Melly's team was nitpicking at this company that stores all the jail call footage and everything, and the record custodian. Turning to the affidavit itself, the affidavit complies with the requirements. Kathleen Casey has been the records custodian for the jail calls for the Broward Sheriff's Office for over 20 years. She was part of the initial setup and installation of Securus at Broward County. Wow, that's a long time to handle all that. Jesus, 20 years. Sheriff's Office was trained by Securus, is the administrator for the system, and wrote the book on the use, maintenance, and storage of these records. When a request is made for the records, the calls, she accesses the cloud servers maintained by Securus, verifies the information, then provides the records, along with certification. And contrary to the defense assertion, it is not necessary to call the person who actually prepared the record. The record custodian or any qualified witness who has the requisite knowledge to testify as to how the record was made can lay the necessary foundation. Broward Sheriff's Office jail calls by the way of business records have been accepted and evidence hundreds if not thousands of times by the courts of Broward County, including by this court for over 20 years. And the records custodian in likely every instance was Kathleen Casey. So this paragraph right here basically shows you that Melly's team is nitpicking at something that is usually never a big issue in court, especially in Broward County's courts. And this is what Melly's team has done a lot. They kind of nitpick at things and try to anything they can to make it harder for the prosecution. And I know it's like, that's a tactic, bro. Of course it's a tactic. They're going to make it more difficult to do shit. The defense conflates the validity of the records with the contents of the call. The records custodian does not deal with the contents of the call, just as they would not deal with the financial entries and the bank records, the doctor's notes and medical records, or the details of the call logs. A records custodian generally only testifies that the record was properly maintained, logged, and stored. Separate witnesses might be called by the state to identify the parties to the call, thus making the call relevant. Okay, makes sense. Contrary to the defense argument, these are the records of the Broward Sheriff's Office and not Securus. BSO does control them and can put calls as needed, much as business could download any record from a cloud server. The defendant's reliance on SHA is misplaced and appears to cherry pick portions of the analysis which are taken out of context. And SHA, I don't even know if I'm saying that right. The government sought to introduce a business records certificate from Google in order to authenticate emails from a defendant. In regards to this email, is that the court found Google was not a party with knowledge, and because the government did not authenticate the content of the emails as being the defendant's statements, they could not simply rely on Google's business record affidavit. Although ignored by the defendant, this court in SHA is very clear. It seems like Melly's team is trying to get these jail calls to obviously not be in the trial, but it's not going to happen because they're allowed to be in the trial. And they were just nitpicking at the custodian that deals with all of it. Kathleen Casey's affidavit sufficiently authenticates the calls as being jail calls from the BSO jail. These jail calls must also be authenticated as being made by who the state claims them to have been made by, which is something routinely done by trial attorneys throughout this courthouse. Not doing so flies in the face of basic evidence rules, relevance pursuant to blah blah blah. Florida courts have found that admitting jail calls through records custodians who works for the sheriff's office is proper under the business records hearsay exception. Authentication for the purpose of admission is a relatively low threshold that only requires a prima facie showing that the proffered evidence is authentic. Okay. The ultimate determination of the authenticity of the evidence is a question for the fact finder. The defendant argues states as soon after the arraignment as practicable or 60 days prior to trial, a party intending to offer an evidence under this section an out-of-state record of regularly conducted business activity shall provide written notice of the intention to each party. The defense reliance upon this has no bearing on the Broward Sheriff's Office jail calls kept in the ordinary course of business, and therefore this argument is not relevant to the subject matter of this motion. So Melly's team relied on a certain statute right there, and then the prosecution came back and shat on it. Essentially, the defendant's motion clearly confuses the two statutes. Reasonable written notice is required. Reasonable written notice is not defined within the statute, only that the party has a reasonable opportunity to challenge the records. For example, the amount of notice that is necessary to provide a meaningful opportunity to be heard is not the same for an evidentiary hearing as it is for a status conference. 60 days only applies to the civil cases, and 2 counts of first-degree murder does not fall within civil court's jurisdiction. So Melly's team confused two statutes and thought that something involving civil cases was the same as first-degree murder charge case. Further, the defense final argument is moot. Records custodian certification as to the jail calls were previously recorded and were introduced at the first trial. The parties are no longer in trial, which at prospective start date is now March. So it looks like they scheduled a hearing for the removal of her electronic monitor on February 9th. It looks like Melly's lawyers are going to be doing some depositions of these three police officers right here. Gorell is the guy that apparently Moretti said to lie and say he was in the room too, remember? I don't recognize these two names right here, but they're police officers, I'm sure. They're part of the case in some reason, but I don't know. For sure, I don't remember. Terrible memory. More depositions right here is FBI agent for the phone records and the DNA guy, Kurt Rhodes, right here. Jose, I forgot, but I think it's a police officer. So this is a document the state filed. Looks like they're just putting into evidence 284 detention communication records, 567 detention communication records, DSO jail surveillance videos, 517 detention communication records with fucking phone calls to Cortland Henry, certified records from all the Facebooks of Cortland Henry and Melly, and Instagrams and Snapchats, more Instagram of Bortland, T-Mobile, a bank, another SunTrust bank, JP Morgan, Sprint, T-Mobile. So I think this is just them handing over all this evidence to the defense to just make sure that the defense doesn't say they didn't have it, like always, because they keep doing that. A motion hearing is set for the 26th on Friday, which is my girlfriend's birthday, so I probably won't be able to even record that day, but I'll probably try to get up on Sunday or Monday on my analysis of it. They're going to try to go over as many pending motions as possible. Pretty crazy that Felicia Holmes still has an ankle monitor on. That's kind of bullshit in my opinion. Comment down below what you guys think. I love you guys. Subscribe right now. Peace out.